What up, YouTube world? I am back, and today I will continue with reading the National Board of Certified Counselors Code of Ethics May 2023 version. This is part 2. This section is called Counseling Relationships. Counselors shall take proactive measures to avoid harming their clients and avoid imposing personal values on those who receive their professional services. Counselors will seek to minimize unavoidable or unanticipated harm and, where possible, seek to address unintentional harm. 18. Counselors shall respect each client's privacy and shall solicit only information that contributes to the identified counseling goals or facilitates the counseling process and is also consistent with counseling protocols. 19. Counselors should not share client information that is obtained through the counseling process with specific written or consent by the client or legal guardian, except when necessary to prevent serious and foreseeable harm to clients or others, or when otherwise mandated by federal or state law or regulations. 20. Counselors generally shall not accept goods or services from clients in return for counseling services in recognition of the possible negative effects, including perceived exploitation. Counselors may accept goods, services, or other monetary compensation from clients only in cases where no referrals are possible or appropriate. The arrangement is discussed with the client in advance. The exchange is of a reasonable equivalent value. The exchange does not place the counselor in an unfair advantage. The arrangement is not harmful to the client or their treatment and is documented in the counseling services agreement. Counselors shall not accept gifts from clients except in cases when it's culturally appropriate or therapeutically relevant. Counselors shall consider the value of the gift and the effect on the therapeutic relationship before accepting. Acceptance of a gift shall be documented in the client's record. 22. Counselors shall be mindful of engaging in counseling relationships with those individuals with whom another relationship, such as a community connection, friendship, or work relationship exists, i.e., multiple relationships. Counselors strive to avoid multiple relationships with clients to the extent possible, except in cases when it is culturally appropriate or therapeutically relevant. In the event that a multiple relationship develops in an unforeseen manner, the counselor shall discuss the potential effects with the client and shall take reasonable steps, to resolve the situation, including termination and the provision of referrals. This discussion shall be documented in the client's record. 23. Counselors will exercise caution and avoid exploitation or the appearance of exploitation before entering into a non-counseling relationship with a former client. A period of 5 years is recommended, and counselors shall exercise caution and avoid exploitation of former clients. Counselors will discuss with the former client the important relevant considerations, including the amount of time since counseling service termination, duration of counseling, nature and circumstances of the client's counseling, and the likelihood that the client will want to resume counseling at some time in the future. Circumstances of service termination and possible negative effects or outcome. Counselors will respect the autonomy of each former client and not use undue influence to form any sort of relationship with the former client. 24. Counselors will not engage in any form of sexual or romantic contact with the client or former client for at least 5 years following the date of the counseling service termination. 25. Counselors will not engage in any type of harassing behavior towards clients, which is defined as any verbal, nonverbal, electronic, or physical act that is known or reasonably understood to be unwelcome or that are of a severity that is reasonably would be perceived as harassment. Counselors will take proactive measures to avoid interruptions of counseling services due to illness, vacations, or unforeseen circumstances to prevent the harm that may occur if clients are unable to access professional assistance. Such measures shall identify other qualified professionals with whom the counselor has a working agreement or a local emergency service agency that can respond to a client in a mental health crisis. Counselors will also take proactive measures to avoid interruption of counseling services when leaving their place of employment. 27. Counselors shall protect against unauthorized access to confidential client information in all formats. Counselors will inform and ensure all other persons with access to confidential information on the importance of observing confidentiality procedures and protocol. Counselors shall create and follow written procedures regarding the client confidentiality rules and handling of all of client records in the event of the counselor's death, incapacitation, unforeseen and likely interruption of services, and end of employment. The procedures shall explain how client confidentiality and records are maintained. The procedures will also identify those counseling professionals and/or support staff who are familiar with the relevant ethical and legal requirements of the counseling practice and who will assist in locating other professional mental health providers and ensuring that appropriate transfer of client records. Counselors should provide the client with such written procedures and will provide an opportunity for the clients to discuss concerns regarding the process as it pertains to the transfer of their record. Counselors shall discuss with prospective clients and document the appropriateness of counseling services offered. If there is reasonable cause to believe a client will not benefit from counseling services offered, counselors will explore alternative forms of treatment and/or discuss and/or facilitate a referral to another provider. Counselors working independently will retain and protect client records as directed by state or federal law. Counselors will dispose of records in a manner that protects client confidentiality. Counselors shall make efforts to inform clients and former clients of the court-ordered release of confidential client information prior to such release in a prompt and timely manner. In the event that the client seeks to prevent the release, the counselor may request that a court withdraw any order to release confidential information due to the potential harm to the client or the counseling relationship. When ordered to disclose confidential client information by a court or governmental agency, counselors will release only that information required by the court or agency. Release of information will be documented in a manner consistent with the practice written procedures. Number 32. Counselors shall inform clients of the purposes, goals, procedures, limitations, and potential risks and benefits of services and techniques either prior to or during the initial counseling session. Counselors also will provide information about clients' rights and responsibilities, including billing arrangements, collection procedures in the event of non-payment, confidentiality and its limitations, and records and service termination policies as appropriate to the counseling setting. This professional information will be provided to the client in verbal and written forms, such as a counseling services agreement or professional disclosure statement. Counselors will confirm that the client understands the provided information and obtain written informed consent to participate in counseling. Counselors will document any related client concerns related to the information provided in the client's record. Counselors understand that clients own content of their clinical records, and counselors work to provide reasonable access to the content of the records when requested. Counselors will respond to client requests for access to or copies of records in a timely manner. Additionally, counselors will provide an opportunity for the client to discuss the content of their clinical record. If there is reasonable basis to believe the direct review of records will cause the client harm, the counselor will discuss the requests and possible effects. Counselors will document each client request for records in the client's record. In the case of minors, counselors may limit access to minor, client, or responsible guardian if there is a compelling evidence that others' access may cause harm. Counselors shall obtain a client's consent prior to the provision of services. This consent shall be documented in writing in a counseling services agreement, professional disclosure statement, or other written form. This agreement or statement shall become a part of the client's record. 35. Counselors shall work collaboratively with clients in the creation of written plans of treatment that offer attainable goals and use appropriate techniques consistent with the client's psychological and physical needs and abilities. 36. Counselors shall update and modify the client's record throughout the counseling relationship when changes occur in the treatment plan, including changes related to goals, roles, techniques, and diagnoses. Counselors shall obtain each client's written approval for such changes. Counselors shall clearly identify in writing the primary client in the record. Counselors will also identify in the record those individuals who are receiving related professional services in connection with such client relationship. In the context of couple, family, or group counseling, the counselor shall not reveal any individual client confidences to others without the prior permission of that individual. 38. Counselors working with minors, incapacitated adults, or other persons unable to give legal consent to release confidential and privileged information shall protect the confidentiality of information received in the counseling relationship as specified by federal and state laws, written policies, and applicable and ethical standards. In all cases, the counselor shall discuss with the client and their legal representative the limit of confidentiality and the rules concerning the release of any information. 39. Counselors respect and honor the inherent and legal rights of the parents and legal guardians and minors and incapacitated adults who are legally incapable of giving informed consent. As appropriate, the counselor shall collaborate with parent or legal guardian discussing the role of counseling, the confidential nature of the counseling relationship, and the autonomy of the client as required by the NBCC Code of Ethics, state and federal law, and other applicable ethical standards. When working with minors or incapacitated adults who are legally incapable of giving informed consent, the counselor shall consider the custody agreement of a power of attorney document or legal agreement that may impact the rights of a parent or legal guardian. Number 40. Counselors are encouraged to consult with both parents or other family members prior to delivery of service in joint custody arrangements to ensure agreement with treatment planning and record sharing. Counselors will seek permission of an appropriate parent or legal guardian to disclose information and obtain voluntary and informed consent to release confidential information when counseling minors or adults who are legally incapable of providing consent. Counselors will advise their client of this action in a manner consistent with the client's level of understanding. This completes the counseling relationship section of the LPCC Code of Ethics. Thank you.